Hello, it's Phillip Taylor speaking from Richmond Green Chambers. This morning I'm looking at a book from Oxford University Press, which is on an area which strikes horror into the hearts of some practitioners. Not all, of course, because it's quite a useful device sometimes. It's the Law of Proprietary Estoppel. Estoppel being a word that a lot of people have difficulty with. This has been written by Ben McFarlane, and it's an important book. It's a heavy book, this one. It's a hardback. It runs to something approaching 650 pages. Starting at the back, you can see a very detailed index. You've got the usual structure for the OUP books. You've got paragraph numbering at the sides, very detailed footnotes, which are extremely helpful when you're looking for particular things. And of course you've got the usual structure at the front of each chapter. Nice little index so you can try and find things, navigate around it pretty well indeed. It's always worth reading the foreword, and in this case the foreword is written by Lord Neuberger, whom we will talk about in a moment. And he wrote the foreword in August of last year, 2013. There's a preface again from the author. Then you've got the cases and various other points, and you've also got a relatively short set of contents, which you can probably see there, and just going over, it's not a particularly large number. But the book itself is invaluable from a lot of points of view, because if I can put it this way, we've moved back to a much more orthodox position, I think, when it comes to looking at the concept, the doctrine of estoppel itself, after years of what I would call slight change with Lord Denning in particular, who I have very high regard for, because I could see why he was bringing estoppel in as an equitable jurisdiction, an equitable remedy, if you like, almost in the sense of trying to ensure that a proper form of justice was taking place. That, as you know, did not go down well with many of the more orthodox members of the judiciary. So therefore we have had a return to more orthodoxy, but more of that in a minute. The title we've given the review is The Renaissance of Proprietary Estoppel, a timely examination and overview with a foreword by Lord Neuberger, whom, as you probably know, is President of the Supreme Court and extremely learned and very experienced in, funny enough, IT, which is very helpful because we're very much moving towards a new era at the moment in the way the courts are being run, and the way in fact we deal with matters when there is contentious litigation. So if even for seasoned practitioners the term proprietary estoppel seems betimes arcane, rest assured it isn't, at least not anymore, thanks to Mr. McFarlane. As Neuberger's foreword reminds us, primary estoppel has had a remarkable renaissance after having lain virtually dormant for much of the preceding century. And we've had a bit of tinkering here and there, but it's cropped up, even in my practice, on a number of occasions. You hear the dreaded words from the judge, "Oh, estoppel, Mr. Taylor, it may be that." You think, right, have I thought about that area? Because it is an important area for us to always remember exists. Lord Neuberger says this: primary estoppel sprang back to life less than 50 years ago in two decisions of the Court of Appeal, in which the court was seemingly unaware, according to Neuberger, that it was indeed relying on proprietary estoppel. Since then, many cases have emerged involving the legal concept itself, including 3 in the last 10 years, basically the beginning of the 21st century. Time then for this timely work of reference on the subject, which has been written by Ben McFarlane and published by OUP, Oxford University Press, to be looked at in some sort of detail. It's a wide-ranging, detailed and an excellent analysis in our view of this newly emerging and actually re-emerging area of law, because it's been there but it's being revisited effectively. It's practical, reassured, balanced and reasonable. Those are the words I think we can use, and the book will be much relied upon, says Neuberger, by practicing lawyers and judges. And I think that's important because estoppel, preventing, stopping, the concept itself is sometimes subject to a bit of confusion. It's not quite as worrying as you might think when you think about what it's there for, but just the very words themselves make it sound technical and something you want to run a mile away from. So if ever you as a practitioner have cause to feel that all too familiar frisson of fear in court when proprietary estoppel raises its head, you need fear no longer. Not when you have this reassuring erudite book to hand, because it is actually quite helpful, and it's amazing what it does to your confidence if you've got something there you feel, well, there may be an answer in that book, when you're scrabbling around trying to think of what the answer to a particular knotty question might be in court, especially if the judge gives you time to go out and have a quick look at it. As proprietary estoppel is a multifaceted concept, the book demonstrates how and why this is so. The concept has three strands effectively: the acquiescence-based strand, the representation-based strand, and the promise-based strand, any or all of which might or can be applied to issues that frequently concern land or chattels, although not necessarily. Obviously, primarily we're interested in land issues, property issues, real property issues. The author, Mr. McFarlane, makes frequent reference throughout to the texts of Thorner and Major, the leading case, which serves, he says, a useful purpose in outlining the basic form of the doctrine. Lord Walker comes in at this stage, and in that particular case he made the following observation, stating the scholarly consensus that proprietary estoppel, quote, in his words, is based on three elements: a representation on assurance made to the claimant, reliance on it by the claimant, and detriment to the claimant in consequence of his reasonable reliance. And I think you can see something here, a little bit like the law of negligence, duty of care, breach and damage. Think about it, because it's again the little structure, which is very much a hallmark, I think, of English common law. Anyway, Lord Walker's put that point forward, or to oversimplify it if you like, a promise made is a debt unpaid, as the Scots-Canadian banker Robert Service wrote over a century ago in his best-selling verses about the dodgy goings-on during the Klondike Gold Rush. And some of you, I hope, will know his beautiful poetry. Proprietary estoppel, notably the promise-based strand, would have to come in pretty handy in those far-off days in the Klondike, had it been more widely understood and applied at the time. I don't think it was quite like that if you've even actually been to the places and seen what it was like, but you've got a fairly good idea of the device that might have been of some help. So bear Robert's Service in mind when you're thinking about proprietary estoppel. Over a century on, the relatively swift evolution of the law of proprietary estoppel is reflected in this book, which seeks to consider, explain and contribute to the emerging commentary on proprietary estoppel which we've got for the 21st century. There are all aspects of this subject covered in this book, including remedies and the wider legal context. It's logically structured, as you would expect from OUP, with numbered paragraphs, as I've said, copious footnotes and an extensive table of legislation and cases. It's reliable, it's authoritative, and it's a useful practitioner's reference guide, and it should certainly be in every practitioner's library if this is an area you practice. The law stated as at the 31st of July 2013, obviously the book came out much later, but as you can see it's a heavy book. You can get the idea of the sort of thing there. That's an area on the promise itself, formal requirements that come in. There's always a little bit of complexity. It's amazing how complex the law develops quite quickly, especially in anything to do with the equitable jurisdiction. I've always found that there does tend to be more of a cerebral researched element to it all, But I'm very pleased with this. I think it's very helpful to any of us involved, and it does crop up actually in all levels of court. The county court, my practice, certainly this element has cropped up on more than one occasion recently. So thank you to all concerned. I think Lord Neuberger has been extremely helpful with pointing us in the direction, and the work by the author, Mr. McFarlane, is excellent. So thank you to all concerned. Most grateful to have this book. Bye-bye.